can see the numbers are rising, and it's so nice to see so many of you back here today for the second in our Brexit series. We are hoping to share as much useful information as we can through this period of uncertainty. And given that there is a great demand for more on Brexit, we hope to bring you a third in our Brexit series at the end of March. But for now, a big welcome from the Immigration and Public Law team at Goldsmith Chambers. My name is Samina Iqbal. I'm joint head of the team together with Sarah, who's speaking today. That's Sarah Pinder, and we are joined by one of our senior practitioners, Amarjit Seehra, and of course Luke Piper from the 3 Million organisation. He's head of policy there, and we're very grateful for him bringing back more about what's going on in relation to the campaigning that they do and the issues that arise in relation to the settlement scheme. Just in relation to a little bit of housekeeping, we are recording today's webinar. It's going to be available later together with all the slides on our website. We also have a Q&A session for you. Just specifically in relation to that, we thought it'd be nice if you have a question for a particular speaker, before you type out your question, if you put in the Q&A box the name of the speaker, and we can direct the question accordingly. And lastly, of course, we have been asking for a £5 donation for this series of webinars. We've provided links. That's going to the 3 million organisation, the campaign. So we've got the links up there on all our slides, and in fact, all the invitations that you've had. So for today's purposes, I just want to take you through what we are going to be looking at. So relevant documents, when they're needed and who needs them, that's going to be covered by Sarah Pinder. We have found that there have been a lot of difficulties in relation to understanding actually what a relevant document is. So hopefully we'll navigate through that for you. We'll also be looking a little more carefully at durable partners and the qualifying periods in relation to acquiring settled status or pre-settled status, and the difficulties for those achieving qualifying periods during the COVID times. And then Luke's going to be covering through the rights during and beyond the grace period, bringing to you a little more about their report that was published, I think it's now 2 weeks ago. And then lastly, appeal rights and administrative review, which Amarjit will be covering in some detail. I'm sure you're all eager to know as we move through application process through to refusals and what comes next for individuals during this time period. We've put up there the relevant periods, the timescales, and we will add that to all our series, so that that's just something that is flagged up for you. So without much more, I'm going to hand over to Sarah, who's going to take us through to the first part of the webinar. Thank you.
Thank you, Samina, and yeah, welcome everybody. We hope you find this useful. We've tried to build on our webinar from last week that Samina, myself and Luke presented, and from our own experiences, but also from all the questions that we've since received or received as we've gone along. So a bit similar to last week, it is really trying to flag as much as possible. It's difficult to go into much detail in this forum, but hopefully it's enough to flag and you have all of the resources. So just my section in terms of this webinar, we're going to focus on relevant documents. So that is a term in inverted commas that is repeated throughout Appendix EU and within the definitions in Annex 1. So you have here hyperlinked Annex 1 definitions. So again, just click on it when you receive the slides. It will take you to the primary source. And here is a summary, sort of a paraphrase of the definition of a relevant document that is in Annex 1. But do be careful, because there are other sections as well. So there's definitions concerning specified relevant document, and there are other documents as well in Annex 1. So do be careful again to look at the section that you need to. And it is quite difficult to navigate through. Well, quite difficult is an understatement, I think, but it's difficult to navigate through the definitions because of the way the text is also laid out, and there's a lot of prose, a lot of subparagraphs and so on. So do take things very carefully. But for our purposes, really, there's 2 or 3 definitions that really matter, or that most commonly matter. So that's the first one. So it's a document issued by the UK under the EA regulations. So we saw in last webinar that the regulations are no more in terms of being retained as such, as themselves in that piece of legislation, and they've been saved in various other forms of regulations. But if you had made an application before the 31st of December, or historically had made and had received a document issued under those regulations, that is, for the purposes of Appendix EU, a relevant document. The next 2 are less, no less relevant, of course, because they will relate to a lot of persons concerned, but perhaps for our purposes within our community of practitioners, less common. And that is just other evidence where the applicant is a family member of a relevant person of Northern Ireland. So that is a specific category of beneficiaries, so to speak, under Appendix EU, and arose from the Good Friday Agreement and the de Souza legislation. So I'll skip over that, and then I'll skip over the next one as well: document or other evidence equivalent issued by the islands, so the islands, Isle of Man, etc. So again, perhaps less common for the practices that we currently have. And then it's the next 2, biometric residence card issued with a grant of leave to enter / leave to remain. So that is effectively those that may have been granted pre-settled status already. So that's taking you forward in the journey, so to speak, under Appendix EU. So to obtain settled status, or perhaps relevant to family members of that person who has pre-settled status. And then lastly, the entry clearance in the form of an EUSS family permit. So if a family member, for example, has come from abroad, having made an application under Appendix EU family permit, that grant is a relevant document that can then be taken forward into further applications under Appendix EU. So we're not focusing in this webinar very much on Appendix EU family permit. We've got enough to talk about with the first Appendix EU, but that is one of the areas that we want to take forward in the third webinar that Samina briefly mentioned earlier. So all of those definitions coming under relevant document are all caveated by subparagraphs B to D, which I have paraphrased. So again, go to the primary source because you need to make sure that the language is right. I may have made a mistake, so don't just rely on this. And effectively, there is provisions that I just wanted to highlight because it may become relevant as we go on in time. That a relevant document is such as long as it has not been subsequently revoked, as you see at the bottom here, or fell to be so because the relationship / dependency, whichever is the relevant criteria, never existed or had ceased. And also it's a document that has not expired or otherwise ceased to be effective, with exceptions relating to dependent, relative and durable partners if they're renewing an application. So that again is just a flag by way of a summary. So that in a nutshell is what is meant by a relevant document. And it's a term that you will have heard a lot already, specific to certain categories within Appendix EU. And these are the ones that certainly we've had to grapple with the most. So we thought it'd be useful to share this in a bit more detail today. And that is effectively, as you see in this slide, the two categories of dependent relatives and durable partners. So we'll pause for durable partners for now, because we'll see that in the later slides. But effectively, dependent relatives and durable partners are the ones that are most affected by the need to have a relevant document in Appendix EU. So again, you have here Annex 1, you've got all of those definitions there. And dependent relative, I've just summarized those definitions here. To obviously get our heads around it, but also because you'll see in, I think, 2 instances, or one particular instance, it is a wider category than what we knew of extended family members. So effectively, dependent relatives is more or less what we knew of as extended family members under the regulations, but with certain slight changes. So the first is relative, other than spouse, civil partner, durable partner, child, or dependent parent of a sponsoring person. So anybody else that might be dependent. So that could be a cousin, it could be an uncle, brother, sister, that sort of relationship. And such a person who for the relevant period was a dependent of the sponsoring person, a member of their household. So again, that's similar to the old regulations, or in strict need of their personal care on serious health grounds. The other categories of dependent relatives are a person who's subject to a non-adoptive legal guardianship, which may not arise as often, so we won't speak much about that. And then the third, a person under the age of 18 years old who's the direct descendant of the durable partner of the sponsoring person. So effectively stepchildren without having had the marriage to formalize that relationship. So those are the 3 summary categories of dependent relative. And why the relevant document comes in, it's because in the definition, you need to have that relevant document as almost as a confirmation of your relationship. So here the keyword "and" holds a relevant document as a dependent relative of their sponsoring person for that period of residence relied upon. The key exception that is highlighted in the definition is if you have applied for that relevant document, so if you've made your regulations application, for example, before the 31st of December of last year, of 2020, and you still have that application pending, there are saving provisions to govern that, and you don't have that document when you come to make that application under the USS before the deadline, then there's an exception there that accounts for that, and it will be taken as if that document had been issued prior to the 31st of December 2020 for the purposes of the EUSS application. So that's really, in a nutshell, the main exception. So for anybody else who hasn't got that relevant document, then there are some really tricky issues to deal with. So that's the sort of the baseline, and anything outside of that really needs to be looked at very carefully. And so, as I mentioned, the second category that's largely affected by the need for a relevant document is durable partners. So we touched on that a bit again last week, but this is just to provide a bit more detail specifically on durable partners. And again, the way durable partners has been provided for in Appendix EU is really very complicated, perhaps unnecessarily so, and we foresee as practitioners who have tried to grapple with this area real problems to come. There are 2 categories, so to speak, so sort of 2 distinctions in how people might be affected as a durable partner, and they sit either side of the end of the implementation period. So the first one, if you're resident in the UK as a durable partner, using the term loosely, before 11 p.m. on the 31st of December 2020, you need a relevant document for the period of residence relied on. So again, for the period pre-31st of December 2020. And you're also required to submit evidence which satisfies that the durable partnership is effectively continues at the time of your application. So that's the sort of evidence that we're used to collating as practitioners, evidence of cohabitation and so forth. Again, the only exception that's expressly provided for that sort of is the most commonly needed is the one that I touched on in the previous slide. If you have made an application for such a document before the 31st of December, but this has not yet been issued. If you are joining on or after the 1st of January 2021, a relevant sponsoring person as a durable partner, there are provisions for that, not in a durable relationship with the relevant EA national living in the UK at any time before the specified date. So that is in triple AAA of the definition paragraph. And then if you were a durable partner of a relevant EA national and you were previously resident in the UK without that relevant document, aside from anybody who has made that application before the 31st of December, so if you haven't made that application, then you're sort of provided for, but only if you have not had any other lawful basis. Only if only if you were a resident, in the UK with a different lawful basis. So if you were here without any basis or without any basis that's been recognized in law as in like a durable partner under the regulations, so you were here potentially illegally, and you want to try and fit yourself in the category of durable partner, you are expressly excluded from doing so. So you can't get around it by being resident in the UK, not having had a relevant document and not being here in any other category. Rather, it's if you were here as a student, for example, then you are able to perhaps fit yourself in as a joining durable partner. And that is the last bullet point there. So you can make an application if you have had lawful status in a different category. The only other exceptions that are covered in the last bullet point, the only other exceptions are if you've had what has been termed a supervening event or a break in continuous residence. So there are very specific set of circumstances that are outlined in the definitions that meant, for example, you were resident in the UK as a durable partner, but then you had to go out of the UK and there's a supervening event or a break in that continuous residence that means that you can then sort of fit yourself back into that category. But again, that is very specific and needs to be looked at very carefully. The last slide I'm not going to speak to for very much at all. It's just to highlight that there are thoughts in terms of getting round the category of persons that are not married, are in a relationship, and that didn't have the relevant document before the 31st of December, or who haven't made such an application before the 31st of December, then a possibility would be to marry between effectively now and June 2021, if the grace period is going to stay closed to June 2021, then you could potentially fit yourself in as a spouse. So you switch from categories as durable partners into a direct family member, so to speak, as a spouse. But the definition still suggests that you need to show that you were in a durable partner before that period to show that you're not just a new spouse, so to speak, that you've had that history within the implementation period. And so it comes back to a relevant document. So there are real problems with durable partners. And so the more we can get it out there that this is a tricky situation, the more perhaps Luke and his colleagues can campaign and can try and work on all of this to try and rectify it, then obviously the better it may be, but we'll just have to see what's to come. I'm going to run out of time shortly, so I'm just going to cover this very briefly, but we wanted to just highlight in a bit more detail the impacts on residents. As we saw in the last webinar, EUSS is the settlement scheme is very much based on residents in the UK, as opposed to an exercise of treaty rights. And so as we continue, obviously, in pandemic and restrictions due to public health restrictions, the time periods that obviously we may have foreseen this time last year or a bit later last year have been extended somewhat. So it may become more and more relevant as we go on. The guidance that you have at the bottom is the current government guidance for EUSS applications that are in or outside the UK and who may have had absences, and those were impacted on by the pandemic, or as a result of the pandemic. So look at that very carefully. Basically, the first bullet point is a useful one across the board, regardless of the COVID impacts. Absences from the UK of up to 6 months in any 12-month period is not going to break your residence, regardless of the reason. You don't need to submit any evidence as to why you were absent, let's say for a period of 4 months in one period of 12 months. So that's in line really with continuous residence definitions that we are familiar with in other areas of immigration. Second one, a single absence from the UK of more than 6 months, but effectively less than 12, will not break your residence, but if it's COVID related, and you need to look at the guidance in terms of how that's defined or anticipated by the government, but remembering that might not be the outlines of it. It may be arguable to go outside of that on public law sort of arguments. And the third bullet point, the EUSS allows for a single absence up to 12 months for an important reason, including serious illness and study. And this is what is anticipated in terms of a tricky area. There's very little guidance as to what that important reason is. It's not really defined. 2 examples only are given in the guidance, and they are verbatim here, including serious illness and study. What does that mean? And we've just flagged here, courtesy of Luke's highlight, in terms of the organisation Here for Good, another campaigning, advocating organisation on behalf of EU citizens in the UK and their family members. And you have it hyperlinked here for a call for more information, gathering information by way of a survey to see really how that is going to impact. Without data, it's difficult again to argue going forward with the government that things should be different. And then you have more specific examples in terms of self-isolating, but absences of more than 12 months as set out in the guidance as of today's date is an issue, so do watch out for that. And my last slide here, again, an important reason for a single absence of more than 6 months and up to 12. Again, the examples here of how it may be applied, interpreted, but again, it's all in, the proof is in the pudding, effectively. It's all in the evidence, really, that you will ensure to protect those rights. And so supporting letter from doctor, the more the detail, the better. So I hope that's useful just to highlight those areas. And so at this point, I'm going to hand over to Luke to hear more about going forward within this grace period.
Thanks, Sarah, and hello, everybody. Some of you again. I just wanted to follow up on something that Sarah was just saying there about the unbelievable complexity of Appendix EU and the family permit part of the immigration rules, and particularly around durable partners. I think it is made unnecessarily complicated. I think that's largely because of the way that's rooted around the requirement for a document. But it's really interesting because when you look at the accompanying guidance note that the European Commission published on citizens' rights, which I'm just going to post into the chat there, their section on durable partners is only like a few paragraphs long. It's very straightforward in terms of how they explain it to the public, and indeed this guidance is intended for member states to then use that as their blueprint to then adopt in terms of their legislative approach, and it's kept very, very simple there in terms of how it fits together. But I think there's probably more of an illustration of how two legal systems work, and that the UK system of immigration is very much set by codes and rules that you have to tick and follow, whereas EU law is much more principle based. But anyway, what I'm going to talk about are these issues associated with rights during and beyond the grace period. In the last talk that we had, we covered the kind of the instruments that are involved in this, but it's remarkably complex. And if we go to the next slide, I've just highlighted the three kind of key pieces of legislation. This is by no means supposed to be representative of everything that it relates to. In the second two, they essentially cross-reference with, a considerable amount of legislation, particularly the second one, the transitional regulations, which are huge, and they cut across, well over 20 pieces of legislation. But they are essentially, this is about the transitioning from the end of free movement into the new immigration system, but trying to kind of protect and shield EU citizens and their rights that they had during the course when EU law existed. So the first thing to note here is that the primary piece of legislation essentially that brings all of this to effect is the Immigration and Social Security Coordination EU Withdrawal Act. And that piece of legislation is very short, it's very brief, and the effect of it is to bring an end to freedom of movement, which it did on the 31st of December. But contained within that act is a suite of powers that refers to other powers as well in other pieces of legislation, like the EU Withdrawal Agreement Act, which essentially give the Minister, the Secretary of State, powers to amend primary legislation in the pursuit of implementing the withdrawal agreement, essentially. And commonly they've been colloquially called, Henry VIII powers because of the way that they wield such power without parliamentary scrutiny, really. And what's birthed from that are these two pieces of legislation, the transitional regulations and the grace period regulations. And they are immensely complicated. I remember when these were tabled in Parliament, laid before Parliament, I think the debate that we had in total for the transitional regulations between both the Commons and the Lords was something like just over 2 hours, which wasn't enough because of the complexity and the problems that they present, which is what I will be going on to highlight in these next two slides, where we've tried to put a visualization in terms of what people are losing. So this is the first one. And so essentially, the position was that if you were exercising your treaty rights, and I'm just using that term, most people know what I mean by that, then you were protected by EU law. And that was the case when we were a member state. And essentially the EU regulations of 2016, which were then linked with the 72 EU Act, essentially allowed for persons to have a lawful basis to be in the United Kingdom. What these three little sets here show are essentially what rights people have depending on when they submit an application. So the first one is where somebody submitted their application before the 31st of December. If they were exercising treaty rights before the end of the 31st of December, they are protected by the grace period regulations that would therefore allow them to have a full entitlement to welfare benefits, housing and so forth. And if their status was granted to them before the end of the grace period, which as we know is the 30th of June 2021, it's the deadline by which people need to lodge their applications, then they would then fall within the settlement scheme and then have the protection of the settlement scheme at that point. The one below, you'll see that that this is where somebody submits their application during the grace period, but they don't get a decision until after the grace period finishes. And again, you'll see that their rights are protected, again, until a decision is made in the large, but they can't benefit from family reunion because of the way that the rule is structured. It requires, if you wish to apply for a family member to join you after the end of the grace period, you have to have had a decision and a grant of status to qualify, which is erroneous and in our view contravenes 18.1m of the withdrawal agreement. And then the third element of those that missed a deadline, they were exercising their treaty rights at the end of the 31st of December, but they have no legal basis to work, access services, etc., until the final decision is made on their application. Interestingly, though, there is Nhs regulations, so just to kind of put a little summary there of that, which does activate somebody having entitlement to benefits until a decision is made, which is odd. But the reason for that, we believe, is because the immigration minister signed off the transitional regulations. Those Nhs regulations were signed off by a minister in DHSC with the Department of Health and Social Care. So different philosophies, perhaps, and departments are not very good at talking to one another. But I have more preference towards the Nhs regulations, because at least that means if somebody's got an application in, at least they have their rights. At least they can access healthcare until the plan decision is made. So go to the next slide. Things get a little bit messier, unfortunately, for those that were not exercising treaty rights at the end of the transition period. So these are people who didn't have private healthcare, or weren't working to that effect. What we see here is that things are actually quite bad for people who are in this situation. Even if they submitted an application before the end of the transition period, they don't have rights to equal treatment during the course of the grace period. Now, there's a big question mark over rights to healthcare around this, and now I know I've said it quite definitively, but I must caveat that there's a lot of confusion around that. We've been trying to get to the bottom of this with the DHSC, and it does seem to be the case that they're saying yes, they can access healthcare, but they've not updated their guidance to reflect that yet. And we understand from correspondence that they are going to update it to make it more reflective of the reality. But you've got this bizarre situation where people who weren't exercising treaty rights are waiting for decisions on their applications. Yes, they can work, yes, they can rent, but they're not allowed to have access to social security, welfare benefits, and housing support if they're made homeless. So it's a bit of an odd situation, particularly when, if you look at the wording of the withdrawal agreement, which is, it's quite clear that under 18.3, that if you have an application pending with the Home Office, you have rights until the final decision is made. So there's a tension there, and one that we're pushing very hard on. If you look then to the next section, those who submit their application during the grace period, we see the same issue here. But the position is obviously, it descends and gets much worse after the end of the grace period. Their rights are considerably restricted until a final decision is made. And then finally, the third group, so a person who submits their application late, again, like the group of person who is exercising treaty rights, no rights until their final decision is made on their application. Again, we have this bizarre anomaly where the NHS regulations seem to protect this cohort when they submit their application, but everything else, you can't get homelessness support, you can't access welfare benefits whilst your application is pending, you can't work, but if you do fall over and you really, really hurt yourself and you need treatment from the NHS, you'll get it. So it seems a bit odd to me, and we think it conflicts grossly with what the terms of the withdrawal agreement. So just go to the final slide, and which is, what are the problems with this approach? Well, I've already set out visually what those issues are, but the solution is quite simplistic, really, which is that grants of status really should mean full rights. The case of Fratilla which was concluded last year, highlighted this point quite well. Granted, it was under the jurisdiction of EU law. It's not necessarily being considered whether whether the same principles can be applied under the terms of the withdrawal agreement. But it would seem odd to me that the purpose of the withdrawal agreement is to preserve the rights of EU citizens. Why should there be lesser rights if they were considered to be as they were when we were members of the European Union? So those who were given pre-settled status should have the same rights as those with settled status. The next thing is those with pending applications should have full rights until a decision is made. That basically chimes with, I suppose, a concept of Section 3C, leave. But in reality, as we've seen, even if you submit an application late, you don't get any rights, and it seems, again, a tension that needs to be resolved. Thirdly, rights during a grace period need to be urgently clarified. As we said, there's some real concerns there about whether a person not exercising treaty rights should be disadvantaged in the way that they appear to be. And then finally, grants of status to those who apply late should have retrospective effect. Now, the concern is that a grant of leave will only see the person getting leave from that date. So if somebody applies late, so after the end of the grace period, their period of residence in the United Kingdom will be considered for UK immigration law purposes, unlawful up to the point where they're granted status. And again, I don't see where it says that that's permissible under the withdrawal agreement, and that seems to be considerably problematic. So I'll leave it there and pass over to Amarjit, who will talk more about appeal rights and that.
Yes, thank you, Luke. I'm going to start by providing a general overview of administrative review and appeal rights in the context of the scheme. We will then have a look at Appendix AR EU, the 2020 Immigration Citizens' Rights Appeals Regulations, and also caseworker guidance. To understand the scheme, you need to be aware of the relevant dates, and these are set out at the beginning of the slides. They include, for example, the transitional period, which was from the 31st of January to the 31st of December 2020, and also the grace period, which we are in at the moment, which runs from the 1st of January 2021 to the 30th of June 2021. Can I have this slide on general overview? So to begin with, a general overview, I will highlight a few particular points, starting with a section from Appendix EU guidance. This sets out the general approach that should be taken by caseworkers to applications. So it said that they should engage with applicants to help avoid errors or omissions and give them a reasonable opportunity to submit further evidence. So already you can see perhaps a different philosophy from what we're used to in other types of applications, and they appear to be taking a more proactive approach. What's also different here is that you might find that if you receive a refusal following an application under Appendix EU, that you have both the right to make an administrative review application and a right of appeal. So they won't necessarily be alternative remedies. If you pursue the administrative review and it's unsuccessful, then the time for appealing the original decision will run from when the AR decision is sent, or if you're outside the UK, from when the decision is received. This is presuming you haven't already appealed the decision. Also different is the time limit review application in the UK. It's more generous, as you have 28 days instead of the usual 14. The next slide, please. Turning now specifically to administrative review applications, Appendix AR EU is the one to turn to for the relevant provisions when you're making an application under the scheme. The provisions in Appendix AR don't apply, and there's also specific Home Office guidance relating to the appendix, and there are various links at the end of the slides which will help you navigate around this. There are a few points to highlight. You may have an administrative review if you applied on or after the 1st of November 2008 and you received an eligible decision as set out in Appendix AR-EU. It's important to note here that you can provide new information or evidence in the application and that it can lead to a grant of status. So the appendix is actually more generous than Appendix AR. But perhaps this again reinforces the different philosophy that the Home Office appear to be promoting. We've discussed before also that the time limit is more generous if you're in the UK, so you have 28 days instead of 14. And I've also highlighted two further points. The first is in relation to paragraph 34X of the immigration rules. And this deals with the withdrawal of applications when you're considering admin review procedures. There are the usual rules stating that if you leave the UK or if you request your passport to travel, then your admin review application would be considered withdrawn. However, these rules are said not to apply to applications under Appendix AR-EU. Again, this reflects perhaps a more generous approach being adopted. This is not necessarily straightforward because you'll see if you're subject to immigration control, you're going to have to think about what happens if you have Section 3C leave. In the normal course of things, if you leave the UK, your leave is said to lapse. So yes, on the one hand, the rules state that you can leave and your admin review application will continue, but you'll have to consider the potential consequences of this if you're subject to immigration control. And it may be best to seek advice if you're unsure of the position. Another point to highlight is that the Home Office guidance suggests that you can make an application, you can make a new application whilst your admin review application is being considered. I would be extremely cautious about this because it doesn't seem to sit well with the rules, which in fact suggest the opposite. Paragraph 34X again, 4 suggests that if you make another application while your admin review application is pending, then your application will be treated as withdrawn. And there doesn't appear to be an exception to this for the purposes of Appendix AR-EU. So on the face of it, there is a conflict between the guidance and the rules and also within the guidance itself. So but perhaps just watch out for that. Overall, it seems that the Appendix AR-EU is more generous than Appendix AR in several important respects. And next slide to what's eligible decision. This is set out in 1.1 of the appendix. Refusals to grant status under Appendix EU, refusals to grant settled status instead of pre-settled status, where leave granted under the scheme is cancelled because the requirements are no longer met, and when leave to enter granted under EU family permit is cancelled because of a change in circumstances. If you're refused, the decision can be maintained or withdrawn with a new refusal being issued. And you may find that you're provided with a new refusal where the material reasons in the original decision are incorrect, or there are additional reasons for refusal. Very briefly, what can't you challenge by way of admin review? This is referred to in 1.2, the Appendix AR-EU, and is, for example, where the refusal is based on suitability grounds, and you need to turn to Appendix EU 15 and EU 16 for that, or if it's rejected as invalid. So as an example, an application will be refused on suitability grounds if the applicant is subject to a deportation order, exclusion order, or exclusion decision. Next slide, please. Time limits under Appendix AR-EU. The time limits are fairly straightforward. If you're in the UK, they're more generous. As we said earlier, you have 28 days after receipt. It's 28 days also if you're overseas and 7 days if in detention. And note that if you're served in accordance with Appendix SN by email, then you're generally considered to have received the decision on the day it was sent. I've highlighted paragraph 34R3 of the rules. This refers to a discretion to accept an out-of-time application if it would be unjust not to waive the time limit and the application was made as soon as reasonably practicable. Unjust not to waive the time limit seems like a fairly broad expression, but then appears to be circumscribed by stating that the application was made as soon as reasonably practicable. There is only one example of what this might mean in the Home Office guidance, where it refers to someone who is hospitalised following an emergency and then made their application as soon as they left the hospital. The Home Office guidance also states that if the application is made after the deadline, it will be rejected if there are no compelling reasons. It remains to be seen if that's a correct gloss on what the rules say, but for the time being, this is what an out-of-time application will need to address. The government website indicates that you will receive a decision within 28 days. Okay, next slide, please. For the grounds of challenge, moving on to the grounds of challenge, the reviewer will consider whether the decision maker failed to apply or incorrectly applied Appendix EU or published guidance. And importantly, again, whether there is information or evidence not before the decision maker showing that the applicant now qualified for a grant or a different grant. So you'll see this, again, this new and rather generous provision allowing for the submission of new information or evidence, and that it can lead to a grant of status even after refusal. So effectively giving you the opportunity to provide information that wasn't submitted at the time of the application. The gov.uk website states that the new evidence must be provided within 10 working days of applying online, otherwise the application may be refused. The Appendix AR EU also confirms that the Home Office will not seek to remove you when an application is pending. You may, of course, have a right of appeal if you're refused, and we'll turn to that next. Next slide, please. Turning to appeal rights and some headline points, I'll just refer immediately to the Immigration Citizens' Rights Appeals EU Exit Regulations 2020, which came into force on exit day. Right of appeal is provided where you've made a valid application under the scheme on or after 11 PM 31st of January 2020. Right of appeal is also provided in other circumstances where the decision is made on or after that, on or after exit day. For example, a variation or cancellation of leave to enter or remain granted under the scheme. The regulations amend section 3C to extend your leave while an appeal could be brought or is pending. And next slide, please. Just turning to rights of appeal, specifically, they're contained within regulations 3 to 7, and that's chapter 1, part 2. By way of example, this will include where your application is made on or after exit day and you receive a decision to refuse you leave to enter or remain, or where, for example, you're granted pre-settled status instead of settled status. There are also various other circumstances in which you will have a right of appeal, for example, where your decision is made on or after exit day and includes a variation or cancellation of leave to enter or remain. But it's best to turn to regulations 3 to 7, which contain the full provisions. Next slide, please. Pending appeals. An appeal will be considered abandoned where there is a grant of status, but note that this doesn't apply if indefinite leave to enter or remain has not been granted, or if it's cancelled or revoked. So essentially it provides you with the right of appeal where you've applied for settled status, but you're granted a pre-settled status. Appeals are generally suspensive, so removal is suspended unless you have a decision which is certified under regulations 15, which is national security decisions, or 16 in relation to deportation. Regulation 13.5 confirms that an appeal is not abandoned if the applicant leaves the UK. So your appeal will continue, but you need to remember consider the potential consequences for Section 3C leave if you're subject to immigration control. Next slide, please. In terms of time limits for appealing, the FTT and the UT rules have been amended. The time limits are 14 days to appeal after the decision is sent if you're in the UK, or 28 days if outside. However, if there is an administrative review, then your time limits will run from when that decision is sent or received. And just ending on grounds of appeal, actually the next two slides, I've set out Regulation 8 in full in the slides. Essentially, you may appeal on the grounds that the decision breaches your rights under various agreements, for example, the withdrawal agreement, or it's not in accordance with relevant domestic legislation, for example, residence immigration rules or immigration rules. It might be helpful to turn to the withdrawal agreement in certain circumstances if it provides a wider scope to support your appeal, and you'd have to look at that more closely. There are, as always, several different and relevant sources of information spread out. So we've referred to some of the links at the end, towards the end of the slides, which you might find helpful when you're navigating the Home Office website or various legislation. There's also several sources of information on the government website, in addition to the Home Office guidance, which might also be useful. I hope that that's helpful as a general overview. Thank you, and I think I'm going to pass back to Samina.
Thank you, Amarjit and Luke, for that really helpful overview in relation to both the issues raised and the areas covered. Before we move on to question and answers, if I can just tell you what's next for us, we'll look out for our next Brexit themed webinar, 30th of March, the link's there so you can go to that to book, and of course donations, as I flagged at the start. We have on Tuesday also a Windrush workshop for anyone who wants to know more about nationality and the Windrush issues that we've been reading about in the news. But thank you, and we're going to come over to questions. We know that there's been many questions in relation to the EU settlement scheme, and specifically in relation to categories. I'm going to hand over to Sarah to start with, and we'll try and answer as many questions as we can at this stage. Anything that we don't get to, we will later try and answer and put out the questions with you when we get the slides out, as well as the recording of this webinar.
Thank you. Yeah, a huge amount of questions. So it just shows again, obviously how pressing this is, but I think a very big B in terms of how complicated this is, because we all are getting our heads around it. So I'll take a few together, I think, because there's some sort of threads that are quite common. So there's Renee Fickling's question first, in terms of an EA national wishing to bring wife's child, which is the stepson, to join him in the UK, but the wife doesn't want to join and the wife is in agreement. Is there an issue with that? As far as I can see, and I think Samina agrees, that there isn't. There is no, you know, in terms of the regs and the EEA law that underpins that, it's very clear if your spouses, if there's that marriage, children of both parties of that marriage are covered as direct family members. That's been transposed in Appendix EU virtually identically, and there's no requirement for that child to be accompanied by both parents, or that sole responsibility requirement that you might have in other areas under the rules. So I don't think there's an issue with that. And then Kevin Scott's question, I think, is also sort of repeated in theme by Sal McCann's. Effectively, people with pre-settled status can sponsor their family members now under the rules as we know them, applying to third country nationals, so Appendix FM. And that, I think, was recently. I have a vague memory of a free movement article, I think maybe last week. It's a useful source, as we know, particularly on EU. So I think the guidance, that may have stemmed from the government confirming that in guidance. And as both Kevin and Salma confirm, obviously, you know, those requirements then need to be met. So it may be more onerous, but obviously that's always a fallback, and absolutely. So if you can't, I mean, obviously you'd want to put yourself in within the EUSS if you can. And so to have a look at the guidance if there are tricky aspects of it. But if you can't, then yeah, you fall back, or if the relationship is completely out of the EU timescales and so on, then yeah, you can fall back on the rules. And then
I think, Sarah, just to add there, I think that they have amended Appendix FM to include the definition for EU nationals now. So, and that's what I think Colin's Free Movement website was covering as well. So that's useful.
Yeah, because in that category we'll have those sort of, it's the sort of catch-all, isn't it? It's the EU nationals that might have been here before the 31st of December, but where the relationship is formed perhaps way out of the relevant timescales. But also we'll have EU nationals that might be coming over, you know, in December this year, and then they fall now within the same lot as everybody else. But yeah, that's, yeah. Then we had, what did we have? We had a Surinder Singh question from Adeni Adewoye. Family permit to join spouse in Ireland, but now the spouse who's British is coming back to the UK. Effectively, I think, see if the others have any different views, but I would say it's probably best to make an application once you do come here, if they're not here already, because you've got the relevant documents. So we saw that the a grant under as a family permit qualifies as is a relevant document. So upon coming here, then you would have all of that already done, and so you can then qualify on the basis of residence here. And of course that British national would be the Surinder Singh. So he would be known, I think it's, I don't know who's her spouse. Yeah, so the spouse would be, I think comes under the qualifying British citizen category in Appendix EU. So I think there'd be no harm in just getting that done once they come over to the UK.
I think there might also be the time within 3 months of arriving here, then they must apply for the FP if they're not coming with the FP. Permit. So I think that's something to bear in mind as well. And there's a 1st of April 2021 date, I think, which we need to flag up, or which we can come to later as well. I haven't got my head around that date, but that's something that we need to look at as well.
In Appendix FP, right? EU FP, yeah. So more messy and complicated stuff to look forward to if you want to join our webinar on the 30th of March. What else have we got in the mix? Durable, an anonymous question, durable partner slide, can you confirm if joining after the 1st of January 2021 criteria refers to EUSS family permit? So the Appendix EU was amended to include references in the definitions as joining family members and a durable partner who was joining as such. So those definitions are within Appendix EU. As mentioned, we're postponing for now Appendix EU FP, but those applications that I was referring to are within Appendix EU, just to you know, keep it even more complicated. Zambrano, Adeni Adewoye, who is truly keeping us busy with some complicated scenarios. So thank you, Adeni. I think I'm going to have to think again, unless anybody else has some quick resolution on this one. Zambrano, I know there are issues. I mean, obviously there are issues with this one in terms of that history that you've outlined. Am I right, Luke? I hope you won't mind me calling on you. Am I right in saying that there's an issue in terms of how derivative rights has been retained or not?
Well, Zambrano is Article 20 of the TFEU, and that rights associated with that were not retained under the scope of withdrawal agreements, only Article 21 and the related rights. So Zambrano is not in scope of the withdrawal agreement. So if they would need to look to see if they could derive rights through other means. Now the UK government made a decision to give grants of leave to persons that fell within the scope of Zambrano. Now, if I remember rightly, that option is now not available, if I recall correctly. But it's one of those things, unfortunately, that you can't really talk through on a webinar in a minute. It requires quite specific, careful consideration, particularly when you're going backwards and forwards between the rules and trying to kind of get another form of status. I thought, Sarah, the question from Rizwan was a good one, actually, because I think that really highlights a real problem for some family members, I think.
Yeah, because you've got, so Rizwan, non-EU national resident abroad in Sri Lanka, wanted to apply for an EUSS family permit to join her son in the UK. Son is a durable partner because of a same-sex relationship with pre-settled status, but is not a civil partner. So basically, if we transport ourselves back to the regs, mum would have been in difficulty, right? Because relationship of the durable partner were not provided for in the regulations. So we've got that as an issue. And then, of course, that's why the civil partnership comes in as a tool to obviously get around that. And then we have the COVID pandemic issues. So the inability to marry has come in within family heterosexual relationships because of the COVID pandemic. I mean, the all that I've seen is guidance in terms of a sort of very briefly mentioned discretion to consider things on compassionate grounds in because of COVID, if it comes within that timescales. But in terms of how that is applied, how it works in practice, I think we've yet to see. So I don't know if anybody else has any experience.
I'm not feeling very optimistic about Rizwan's client, I'm afraid. But it's as ever with these things, it's you never know in the context of a webinar talking it through. But I think there are going to be a lot of people who may have had plans to get married before the end of a transition period with a view to falling in scope of the withdrawal agreement, and try and benefit from all of the rights associated with that, and they're going to miss out. If they're not durable partners by the end of the transition period, if I've got this right, then that's a big problem for some people. And I think this example highlights a particular tension, which, it's not looking good. But TK's question is actually, which is the one above, Sarah, that one we get asked a lot.
Yeah.
And that's a really straightforward answer, which I'll let you answer. But just to say, I see this a lot. And I think this highlights, it's good that people know to ask the question.
Yeah.
And there's a lot of people who aren't asking that question. And they are going to find themselves in a lot of trouble.
Yeah, absolutely. And so this is where we see, obviously we're trying to do our best in spreading the word. Obviously the 3 million are as well, but there's only so much that we can do. And basically, if you have permanent residence granted under the regulations, yes, you must apply for the EUSS. You're in the grace period now, which obviously Luke touched on. But you must, it's a must, and you've stand to risk access to services, risk your status if you don't. And so, we can only continue to spread that.
I think that's completely flags what's going on at the moment and why we need more of these Brexit webinars just to spread the word, and that's what we intend to do together with 3 Million. So hopefully we'll get out there and we'll catch everyone who's unable, who doesn't know what's supposed to be happening and thinks that PR is enough, but unfortunately it's not.
And that question, just in terms of TK's question, and links in a bit with Peter Larkin's in terms of person who has PR but has applied for naturalisation. And as a result of the previous talk we did last week as well, I was asked the same question. Well, they could just apply for naturalisation now, so why necessarily bother with the USS? Obviously, it depends on the timescales for that person and eligibility for naturalisation. But again, there is a risk. So in terms of Peter Larkin's situation, the client situation, if it's not approved by that deadline, well, again, in theory, you're risking, the client's risking their status in terms of not converting, so to speak, the PR into settled status. So
just to say that I see a lot as well. At least in our inboxes, because we don't give advice, we get a lot of people asking us questions and we signpost people out. But I see that question a lot.
And I think nothing's lost by making both applications. It doesn't cost anything to make that settled status application, have that, and then continue to secure through PR, because the only problem with settled status when you have it is that you'd have to wait for another year before you naturalise, which is why I can see that individuals are kind of confused about whether or not to apply right now when they have permanent residence and they've had that extra year in order to qualify for naturalisation. But there's no reason why they can't use any historical period to continue with a naturalised application, even if they hold settled status at the same time. So I think that's again something that we need to flag up a little bit more, that have both side by side doesn't stop you. Historical residence periods, permanent residence is still usable essentially for naturalisation applications.
Yeah. And the COVID impact on naturalisation applications as well. So whether it's like passport applications have also been, timescales have been impacted, naturalisation is going to be impacted, not only the COVID impact, but perhaps a rush to get these applications done as well. So bear that in mind when you're kind of weighing up the two, or waiting for one to see if you've got to do the other. And as Samina says, there's no harm in doing both, particularly for those EA nationals, for example, that will have an ID card and a passport. So, there may be some flexibility ID document wise and so on. But yeah, I think loads of questions. We'll try, I don't think we can take any further, but we can try and answer them in writing as best as we can when we prepare the slides and the recording of today's session, which, as Samina said, will be made available to all those who registered and later on our swanky YouTube channel.
So thank you, everyone. I think we will end there, and we have gone slightly over time, but we look forward to welcoming you quite soon back on Tuesday, in fact, and then again on the 30th of March for our next in the Brexit series. So thank you again.
Thank you, Samina. Thank you, Luke.
Thank you.
And Amarjit.
Thank you.